So once again, good evening, ladies and gentlemen. Today we'll be having a very erudite speaker, someone who has, so to speak, paid his dues, is a veteran in the HR space. His name is Jimmy Mokikan. I've had the privilege and pleasure of knowing Jimmy for over 20 years. Currently, Jimmy Mokikan is the head HR at Smart Cash PSB. Okay, that's one of the companies, one of the fintech companies into agency banking, payments, and so on and so forth. They are also a sister company to Airtel. Proud to now, Jimmy Mokikan worked for 12 years at Union Bank of Nigeria. While at Union Bank, he held various roles, including rewards, benefit, and regulatory manager, team lead HR operations support, lead pensions. Before that, he worked with Globacom, where he functioned in the training and recruitment as a specialist. And he started his career 2003 with Ristral Consulting as personnel support officer. Jimmy Mokikan has an MBA from Obafemi Awolowo University. He also has a bachelor's degree in business administration from University of Ilorin. He's also a proud member of the Chartered Institute of Personnel Management of Nigeria. Anytime from now, he's going to unmute and kick off the conversation. Okay, so while he does that, let me just quickly say this upfront. Now, why do we need to have a disciplinary process? If you work in a very structured organization, in a very structured firm, one of the things you will see is that they have what we call a sanctions grid or consequence grid. In other words, there is an array of possible infractions and the consequence for committing those kind of infractions. So if you forge certificates to secure employment, the outcome is what? Once it is proven beyond every reasonable doubt, that it is what? Dismissal. Now, take something like insubordination. If you are not careful, what is insubordination? That is why you really need to have like a sanctions grid or a consequence grid, typically embedded in your grievance procedure, okay, in your disciplinary procedure, because you don't want to leave things at the discretion of line managers. Now, let's get this straight. Line managers are good people. Even for those of us in HR, we also double as line managers for people. If people come late repeatedly, how many times is too much? Is lateness even an offense? These things should be clearly communicated, clearly articulated. I'm saying this while we are waiting for our speaker to take over. I have some experience, well, to be modest, but quite robust experience in this area too. One of the things I realized, especially in one-man businesses where the owner or the ownership and the management is embedded in the same person. Typically, the owner or a senior person can say, oh, take out so person. By the time you drill down, what did this person do? It can be as petty as he didn't greet me yesterday. Hello, is the consequence of not greeting me yesterday equivalent to a sack? So, disciplinary process seeks to achieve multiple things. One, it seeks to even let us know, so to speak, what is right from what is wrong. And that should not be based on the interpretation of individual line managers or individual employees. That's the first thing I would like to say. Next, a disciplinary process will also provide a framework for what we call fair hearing. Fair hearing. What is fair hearing? This is a situation where, so to speak, an allegation might have been laid towards an employee, maybe an allegation with respect to a particular infraction. Okay. And this person, for example, at least first in writing, can respond to either agree or dispute with facts the allegations. Then we can go on to what we call a DC. What's a DC? A DC is a disciplinary committee where it can be, nowadays, it can be virtual, it can be physical, a panel, okay, of people 3, 4, 5 people, cross-section of people, both in experience, maturity, and people with integrity, people that you know are reasonable, okay, can look at the case dispassionately. Again, what are you trying to do? You don't want a situation where it is the same MD that made the allegation that is the judge in the case. This is fair hearing. Jimmy, if you are available, please put on your video and start. I'm just holding forth for you, okay? I need to be sure when you are available. Currently, I'm not able to check my chat message because I'm the one talking. So I will need you to please put on your video, speak so that you can take your session. I don't want to go into your slide for you, but I hope 1 or 2 people are getting 1 or 2 things. Let me also quickly say this while waiting for Jimmy, that the disciplinary architecture at best practice, based on my understanding now, to sort of also mirror the judicial system. Okay, Jimmy, let me check. Jimmy is unable to unmute. Can any of my admin help, co-admin? So I've made you co-host. So you should be able to unmute. First of all, start by sharing your slide. So let me just wrap up this my tiny conversation at this point. Jimmy, I've not seen your note and I'm not trying to put you in trouble. Okay, I'm just holding forth like you taught me. I'll also say 1 or 2 things about Jimmy before he starts his class proper. So, if you look at the judicial system, at least in Nigeria, look at it from a working system. I know some of us want to throw this salvation. In the judicial system, you typically have what we call like a police. The police typically says this is the offense and then takes the accused to court. Generally speaking, I will advise that in your organization, the audit too should be the petitioner in certain cases, maybe cases like fraud and the like, so that they are the one doing what? The investigation. Then HR sets up the disciplinary committee, cross-section, the audit comes, make a presentation. The individual or employee facing the panel also can, of course, prior to this, there will have been audit queries, response, as the case may be. This makes the system more transparent and gives a semblance of fairness. Let me end with this. I may come back depending on how today flows. Jimmy has put me in the flow. Don't forget and always remember, I'll say that again, don't forget and always remember that a disciplinary case in your organization may end up in court. Please permit me to say that again. A seemingly trivial disciplinary process or case in your organization may end in court. So every case you are handling in your organization, including just issuing a query, have that in mind. I hope I've been able to lay a good background. But let me just say this on a lighter note. My first major career breakthrough, Jimmy was instrumental to it. Some of us pray, we say, my destiny helper. Please, Jimmy is one of my destiny helpers. So you must know that I hold him in extremely high esteem. He knows it. Any opportunity to say thank you, I don't fail to take it. Jimmy Mokikan is extremely humble, very versatile. Jimmy, over to you. Thank you for coming. He's also a member of HR Mentorship. He's on Mentorship Team 1. He doesn't talk too much because he's busy. But don't forget, he's my destiny helper. You will do well to connect with him. Take it away, Jimmy.
All right. Good evening, everyone. I'm so sorry for, interestingly, Yemi had called me 30 minutes ago. We had done tests and all of that. And then just on the dot of 7, I started having some network challenges. I'm so sorry about that. I had to quickly switch to another laptop. I don't know if the problem is with the laptop. And Yemi, I'm struggling with sharing. I don't know, maybe I'll just quickly send the slide to you. Maybe you help me project, but let me just see what 1 or 2, 30 seconds to see if I can achieve that. I don't know why it's not coming on at all. But can everyone hear me?
Yes, we can hear you, Jimmy.
Okay. Sorry, I'm trying to, I don't know. So I switched to my official laptop to just quickly see if I can sort that out there. I think it should come up.
When you try to share, what does it say?
Okay, it's coming up now.
Oh, that's good, because I don't like sharing for other presenters. You lock me into the presentation and you won't share your honorarium with me.
Okay, can you see it now?
It's coming up, Jimmy.
Okay.
We have about 43 people on this call. We need more people. People will keep coming to the group to be asking questions. This seminar or webinar will solve for them permanently. All right,
Okay,
you can see your screen, Jimmy.
Okay. All right. So good evening, everyone. It's a pleasure to be here, and thanks for the wonderful job everyone is doing, particularly Yemi, my friend. People think I'm tall when they see me, but when they see tallest, say, oh, there's someone who is taller than you. And then we have a traditional picture, there's a way we usually post when we see people who are not as tall as us, the way we snap with them. So thank you for this opportunity. So, because Yemi also plays very well in this space of EIR, he's also spoken a lot about what I have in my notes. So we'll try and do more of maybe Q&A. I'm not doing my traditional presentation style. I prefer, graphics, pictures, and all of that. But EIR will do a lot of writing, we do a lot of talking. So we'll probably do a bit of a reading, and then just to, understand a bit, at least remind us a bit of some of the things we know. So we're looking at overview of, employee disciplinary process. What exactly does this mean? So, in starting my slide, reading here says a disciplinary procedure is a clear process, enabling employers to address issues of misconduct that might be committed by employees during the course of their employment. Things happen. Yemi was given an example, and when he was saying it, I just remembered, a particular incident that happened when I was managing this process for my former organization, where somebody had come and said, somebody is always coming late. I want that person to be suspended. I want that person to, be sanctioned and all of that. So the question then is, what is the definition of coming late? Has it been clearly, defined? So these are some of the things that we help us in the area of, employee discipline. It would also be good to, have a feel of the audience. Are you an HR person? Are you head of HR? Are you, an employee on the receiving end of HR? HR. God will have mercy on us, HR. So what this does is it sets a framework to operate within to ensure that there is consistency of treatment, yet also allows for individuals and mitigating circumstances to be addressed and considered. As we progress, we would see some of the basic, guiding philosophies when it comes to, again, we're being careful with the use of the word discipline. When you just say you want to discipline an employee, there's this air of arrogance, there's this air of superiority, but it doesn't always have to be so. So why discipline? We said is required to regulate the workplace and to ensure compliance with policies, procedures, and values. I work with Smart Cash now, combining a hybrid of, traditional banks and fintech. And I was asking a few people, so if you I think about 2 weeks ago, I was asking some of my colleagues, I said, please send me, I need BVN for everybody's BVN. I know somebody actually walked up and said, why are you asking me for my BVN and all of that? So I made the person realize, see, there are some compliance requirement that we need to fulfill with the regulator. So, and this is one of those information that I need. So basically what this is doing is to ensure there's compliance, Violations of policies and procedures are not regulations guiding the conduct of any business. Is sufficient ground for disciplinary action, and it can range from verbal correction to dismissal, depending on the gravity of that misconduct. So, what we're saying is, when there's a violation of policy, I remember a particular organization that we had transactions with, and they violated. It even went beyond policy. They violated, well, let me not say violate, but there was a breach in, the acts that sort of guides the operations of that organization. And it took the intervention of, divine intervention, let me say that way, for the regulator not to revoke their license. So violations can lead to disciplinary action. What we're also looking at, again, more of the objective is to emphasize deterrence and correction rather than punishment. So I had the privilege of sitting as the disciplinary, or as a secretary of our DC, for a couple of years before I left the organization. And one of the things we always try to do is, after each hearing, there are learning points. So number one, it's not everybody that faces DC, and Yemi spoke about it earlier, the disciplinary committee. It's not everybody that faces the disciplinary committee that will be sanctioned. As a matter of fact, there are people who have come to disciplinary committee and the outcome is, let's give letter of commendation, for these people. So oftentimes people see it as punishment. People see it as, when you say you are facing DC, I've received several calls and say, I can't sleep, I'm praying, what is the, sometimes it's not just about the punishment. Yeah, there are punishments, but it's more about correction rather than punishment. People will say, in Nigeria, do we have correctional facilities like we have abroad? So the extreme sanctions of termination and dismissal will only apply in glaring cases of fraud, integrity issues, and other offenses bordering on gross misconduct, depending on what we also call, what an organization defines as gross misconduct. But again, it has to align with international standards. Organizations must consider effective discipline as a prerequisite to achieving its mission and vision. We look at how does this align with an organization's mission and vision. So for instance, you work in an organization that, you have your customers, you have your values, and then the activities or the character of an employee. So let's say you are managing one of the ones we see oftentimes, these guys who are in logistics, what do you call them? Logistics, vendor management, and all of that. And then you realize that during festive period, a lot of organizations send out messages about gift policy, awareness, how you should treat it, and all of that. So you then look at it, okay, so why are we doing this? Why the alignment with the vision in the first place and the mission of the organization? So it's very important. Now, this last point, very, very important. No disciplinary action should be taken against an employee without an investigation or due process being followed. Tollers made a statement: the decisions you make, the outcome of your whatever sanction can land an organization in court. I was speaking with a lawyer and I said, see, I've not gone to law school. I didn't go to law school to read, to study law. I went to law school. My dad read law also, so I went to law school to see him. However, I have entered several courts in Nigeria, basically all the geopolitical zones, industrial courts, basically. And when you hear some decisions, when you hear some of the reasons why people are in court, you then wonder, why should this case even be in court in the first place? One of the mandates that I was given in my former organization before then was that, you see all these cases, they are old cases. Some due process was not followed. Yemi spoke about fair hearing, due process was not followed, and all of that. The cases are already in court. what are we going to do to ensure that new ones do not just go? Now, it is the fundamental human right of anybody to sue an organization. Sometime last year, we had an audit, my former organization, and the auditor was alarmed at the number of cases. I said, guys, sit down. The problem is not the number of cases. So if employees leave, for instance, and decide to sue an organization, they do a joint action. Maybe you pay, salaries are being paid on 23rd or 20th. And then for some reason, the salary now overlapped into 21st. I can choose to sue you. So it's not necessarily about the number of cases, but it's about the merit, much more about the merit of those cases. Why are those cases in court? So one of the things we then ensure that we put in place is that nobody is sanctioned without having gone through the due process. And then even due process, which we'll speak to, we'll talk about the basic one is a query. What exactly is query? There are a lot of court cases that have challenged what employers call query, and we would speak about that also. Please, chats, I don't know if chats is coming in so I'll try and just read the chat. If there are Q&A questions that we can, I'm sure at some point we would have opportunity to answer all of those questions. Yes, so please, if any auditor comes and tell you have 3,000 cases, tell them it's not in the number. Anybody can wake up and sue. I can sue my wife tomorrow. I can sue anybody. It's not, and you've heard all sorts of very flimsy reasons why people sue. Okay, so moving on to the next slide, let's look at some of the guiding philosophies for managing this process. To build a disciplinary process that must conform to the tenets of justice, it must protect employees against abuses or victimization, and at the same time enables the institution to maintain discipline and orderliness in the conduct of its operations. So I mentioned earlier that I sat as the secretary of DC, and I had issues with a number of some senior executives. If they should do my KPI, I'm sure I won't pass. That's the truth. Because people come in and say, I receive emails, I want this person sanctioned. I receive emails of a function saying, I want to create my own grid. And I'm saying no. I received an email, a very funny one was I received an email saying this particular guy was late for a meeting. Therefore, he must give some sort of a letter, warning, caution, just by being late for a meeting. By the time I started asking questions, okay, is this a pre-arranged meeting? Pre-arranged in the sense that, oh, there was a prior notice that, oh, is it a case of, oh, yesterday I just set up this meeting and then the person did not attend and all of that? So is it a case of, and it's a virtual meeting, is it a case of the person joining? By the end of the day, when we said, we checked I think it was Microsoft Teams, and there was a way we could check, and the guy clearly joined the meeting, even though he joined late. So you see, the focus has now changed from he did not come to meeting to he came late for meeting. So if you don't do that, what would happen is employees, the moment they feel, they feel unprotected, then there's a whole lot we need to do about that. As many of us HR, gurus that are here, managers, we need to look at this very well. We must define what misconducts are, so that there is no arbitrariness. Somebody comes and say, you know what, the person came in at maybe 9:01, and there is no clarity about when is the resumption time. And then when you're saying that the person, you want to sanction somebody at 9:01 for coming late, by 9 you must be on seat and all of that. Again, the person also then has a right to sue you if you delay that person beyond the closing time. If closing time is 5 p.m., if you delay that person to 5:01, I also have a right to make a case out of it. So there must be no arbitrariness in the dispensation of justice when it comes to disciplinary process. Sanction shall not be imposed on an employee without a formal query and reasonable time for response. So, sorry, while I was editing, I think I removed that bullet point because this is one of the most critical points here. So you get to court, and then there's this argument, this person was queried. And then the lawyer of the claimant then say, my client was never queried. So at some point, the court had to make it very clear, before a query is a query, there must be reasonable time for response. So what a lot of us do is that we do question and answer. I send you a mail and I say, next 5 minutes, you must respond. Some will even, expecting you to respond at that time. The court has frowned against it. You can't even win any case in court by that. So what is a query? Number one, you can't just send an email. I wish I could just do sample of some emails. You say, you send a mail, you were not at work yesterday. Why did this happen or something? Those are things that it looks like a query. However, when push comes to shove, you see technicalities coming out. So when you want to send it, please put query there. It eliminates any arbitrariness. Query, then state what the allegation is. Failure to see a customer as instructed or something, you put it there. And then in the body of the query, you put it there, you were to have done this, as in line with this. Okay, please explain why and all of that. That is not the point when you will say you have committed a crime, you have done it, because query is a glorified word for question and for seeking information. Something has happened and I want to know what has happened. Now, you don't tell the person to respond immediately. It's possible he doesn't have access to the information that he needs in responding. If, for instance, you say somebody should go to a client and you are giving him query for not going, maybe what the guy went, there was traffic, he got there, he had interactions, they exchanged, a number of exchanges happened. And then in responding to your query, he needs evidence that are not readily available to him. So ideally, we would say response to query, at least 24 hours is okay. Give me 24 hours. Don't tell me respond immediately, because these are things that can be challenged in the court of law. Remember, Tolle says your decision can actually, be challenged in the court of law. So just to play safe, when I want to issue out query, I just put the word query, so you will not say you did not know there is a query. And query is not verbal. Query is not verbal. It must be written. The person has to respond to it. So sanctions shall not be discretionary or discriminatory, but consistent with disciplinary process. Now, this first 2 points, I'm looking at the aspect of justice and then looking at fairness. What is justice? What is fair? Fairness requires that, let me know. It's not, we say LASMA, LASMA's modus operandi is that they wait for you secretly and let you commit that crime before they let you know. People enter into one way, not seeing, not knowing that that place is a one way and all of that. It has happened to me before, when all of this removing roundabout and you just lose your way. And then somebody just jumps out from nowhere. Oh, you are wrong, you are wrong, you are wrong. That's not how it should be. Sanctions shouldn't be discriminatory, like I said. It shouldn't be because I like you, because I know you. I've had to face very tough decisions. Yemi and I have a senior colleague that we both respect, Yemi Woli Agba. I'm not mentioning him, but he knows who that person is. And I've had to issue a query to one of his mentees who we were working together. The guy saw that he saw the link and the closeness with this person that Yemi and I know. And then he spoke to the person, and I love that person. And the guy said that the senior colleague looked at him and said, "Guy, your case is bad." Eventually, I had no choice. It was a dismissible offense, and we dismissed the guy. So it won't be because, oh, this guy is my friend, he knows this, he does that, and all of that. It's the reality, is sometimes the very hard part of the job. Yemi spoke about the disciplinary committee. For your process to be effective, there should be a committee that must oversee employee discipline. Otherwise, it will be, we will come back to, if I like you, I don't like you, and all of that. HR, like you said, HR is the custodian of whatever process that is documented and agreed on. The functionality of the DC and the rules of party involved in a disciplinary process must be clearly defined. So in setting up for head of HRs, here, in setting up, you must look at the composition of the composition of the committee. Character, their character, integrity, all of those things must not be in doubt. It must not be in question. And then you look at the functionality of the organization. I worked in the banking sector. And so if I'm going to set up, a lot of the infractions that happen in the course of banking transactions. So if I'm going to have somebody there, I must have the head of operations there. I must have legal there. I must have IT, at least to some extent. I must have, like Yemi also mentioned, who is the person that investigated the matter? Maybe fraud and investigation, whatever the organization chooses to call it, or internal audit. They must be there. And then so the way we call it is the investigator. The investigator will be the one to come and present. Oh, this is the case that we have against this person, Mr. A. Oh, Mr. A was supposed to go to, Mr. A went to this happened. And then in summary, we would ask, what exactly is the infraction that Mr. A has committed? I give you a typical example. Somebody was placed on suspension and then he was eventually dismissed justly. Now, there were people who were in touch, who they exchanged communication while the guy was on suspension. Now, another issue now came up after this guy had been dismissed. And then the investigation team then rounded up everybody who was in contact with this guy while on suspension and asked them to face the DC. The first question the DC asked the investigating team was, is there any policy, any procedure, any guideline that says employee cannot talk to another employee who is on suspension? The answer was no. Case dismissed. Case dismissed. So you must say, so, okay, so I won't say case dismissed. Okay, the answer is no. So what exactly is the infraction that this person has committed? When they couldn't say anything further, case dismissed. So you must be very clear. You must be very, very clear as to what the issues are. I think I'll just look at the charts later. I'm trying to see, but I don't want. Okay, so the disciplinary process, I'd mentioned a few things. So, and if an allegation has been raised, there's something that somebody has done something. The first bit is investigation. Now, while investigating, there could be consideration for suspension. We'll talk about that, but you must investigate. Again, some of the very basic things, and I saw a chat about someone having a one-man business. I give you a typical example. A few months into my new organization, as head of HR, I was asked to give query to someone, and it was from top level. And I said, okay, no issues. I'll investigate and then deal appropriately. However, there was a bit of how do I call it, a communication gap. So it was assumed to mean that go and give query is that I should just go and give query. There was no need for investigation. So by my experience, that wasn't the way I was taught. So the guy didn't come to work, blah, 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 and all of that. And we found out the reason. He had a justifiable reason for not coming to work. As in, I don't want to say the reason, 1000% justifiable for not coming to work. So what am I saying? Something has happened, you must investigate. Okay, if after you investigated, we then discover that, oh, there are infractions, there are violations of policies. Maybe you have a gift policy that says you must declare gift. And then you investigated and found out that, oh, somebody took a gift and all of that. The standard practice is, you know what we mentioned, have a disciplinary committee. Just HR, maybe your internal investigation team, they've done their investigation. The report must be sent to HR because the custodian of the disciplinary process is HR. So they send the report to HR. HR reviews. Very important. I have another typical example where the investigation has been done. The head of internal control had done their bit, and the recommendation was to, lay off everybody involved in that transaction. I reviewed the case and I had a different opinion. I shared it with my line manager, who also was in alignment with me. And we took the report back. And in coming back, the decision was, overturned. So HR must review whatever the outcome of the investigation is before inviting to the disciplinary for the DC hearing. Now, in inviting to DC hearing, and Yemi also mentioned, I think Yemi, or talking about, COVID has brought about virtual and all of that. There are things that we do. There must be an email invite. There must be an acknowledgement. That's one. In the invite, there's a letter that's, there has to be, so if I'm doing a virtual SDC, I must let you know that it's going to be virtual. If I'm going to record it, I need your consent before I record. We do not have right to record without the consent of anyone coming in there. So all of that and must be stated. If you're sending a letter, oh, this is going to be a virtual hearing, the committee is going to meet with you virtually, set up this, that, is going to be recorded. Please give your confirmation that you are aware that you are in alignment with the recording. Secondly, is if it's virtual, are you going to give them data? Because see, people can be funny. The question is, if the hearing becomes hot, you know what will happen? The guy will just tell you, hello, my network is bad, I can't hear you. And then something just happens. So what we should do is, sorry. So let's ensure, if you need the person, if it's going to be virtual, maybe because if you work in a conglomerate, you have different branches across the country and all of that, and your disciplinary hearing is centrally determined. In some instances, it could be regional, it could be central. So albeit whatever the case, so make sure that you make provision for that employee that is coming for that hearing. If the employee is going to go to another branch, usually it's better you ask them, let them go to maybe a dedicated branch and all of that. If you already given them work to say laptop, they'll use their laptop. If they don't have, let a system be set up there for them. Because these are things that when the technicalities begins to come up, I tell you, oh, it was a different system. Different things would happen. Different things would happen. And we also let people know that it's going to be a video session. Your camera has to be on, just to be sure it's you we're talking to. You can see the people on the other side there. So all of these things, they are communicated before the hearing. You get your confirmation. So these are processes. If we don't have that, we can them, and then there's an outcome. In some instances, the outcome can be same day after the hearing. In some other instances, there could be need for further investigation. But if the outcome is going to come out, the decision of the committee is communicated to HR. Ideally, that's why I'm saying ideally, best practice, HR communicates what the decision of the committee is. Now, of course, there will be some approval process, maybe from when the disciplinary committee makes a decision, the CEO approves and then is communicated. However, whatever is communicated must be seen to align with whatever your grid, your sanction grid, your disciplinary policies, your procedures. It must be consistent with it. We took a decision some years back for something that happened. And the employee was eventually dismissed. Not that she didn't commit the crime, they commit the offense. Let me not call it crime now. That's another thing that we need to be careful. And we'll talk about that much later. So not that the offense was not committed. However, in going to court says, that punishment was too revert that punishment and all of that. So what we then did is to review what the sanction grid is. For this, there'll be a final warning for a first offender, then maybe second offender, and all of that. So it has to be seen to be fair. So when these decisions are taken, employees must know that they have a right of appeal. Oftentimes, HR, we are silent about it. I don't want to say employers because we are sitting in for employers. We're silent about it, and it's not right. Let them know they have the right of appeal. There will be a window for appeal. You can't just, make it just open like that. There will be a window for appeal. And then once the appeal is done, appeals committee, which is completely different from the people who sat on the case. The only connection will probably be HR representing HR, maybe to give a report or summary and all of that. So the appeal will review the case, and then, of course, whatever the appeals committee, the decision of the appeals committee would also be communicated. All right, so talking about queries, I've said a few things about it earlier. Sometimes people just dump everything on HR and they want HR to look bad. If you are not an HR person and you're on the call, you are also guilty of this because that's their bad position. When they hear sack letter, query, it's all HR. And sometimes the question I ask is, who is your first HR? Your first HR is your line manager, who understands the details of what you do. Somebody walked up to me sometimes and said, they want a JD, the JD for a particular job. I say, you are the one in that function. Develop your JD, let's review together. I'm not the one that will come up with. Line managers are empowered to issue query. Don't just push everything to HR. Now, for any breach of rule, your line manager, your unit or departmental head shall be, in the first instance, examine all complaints against an employee. It is not very appropriate that something is happening in accounts department, the line manager, the HOD, none of them are aware, and then it goes straight to HR. It is not very appropriate. So the hierarchy in that function should at least get to know. Now, when queries are issued, we treated a case, and in our own feedback, the outcome of the DC hearing is that, You know, the sanction grid says for the first offender, this is the applicable sanction. So that was what we did. And then the investigator came back and said, no, this is like the third or fourth time this person is doing this thing. So all we said is in HR's file, this is the first time. Within the department, it never got to HR. So this is why I said, if query is issued, copy HR. There are instances where some you know what, you want to be nice, you don't want to put HR in the know. You have the liberty to do that. However, when it gets to that point, standard practice is I will only give account of what is in the staff file. I'm not even saying what is with HR, what is in staff file. Whatever will be in the employee's record will have to come to HR. HR will have to put it there. So if it's not there, it's almost as good as it doesn't exist. Now, I mentioned earlier, I won't dwell too much. The employee must be given opportunity to state his or her own case in writing. If it's a query, let the employee respond in writing. Not voice recording, all of those things, they've been challenged several times. They've been challenged. So in writing and with your official email is a guarantee. You don't need any signature, except the person is saying somebody hacked my profile. If that's I work with Smart Cash and my response is coming from blah 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 Smart Cash something, my email address is covered, is accepted. It's if I'm using a Gmail, I can tell you that somebody hacked into my account and all of that. So again, one other thing that some harsh employers do is we ask somebody to come for DC here. We expect the staff to pay. It's not the standard thing to do, the standard practice. The organization that is inviting should bear the cost. Alternatively, make arrangement for maybe regional DC hearings. If the line manager is not satisfied with the employee's explanation, so where response has been given, you can then refer to the next line of authority. You can get to HR and all of that. So this way, you know, you've issued the query, response has come in, you're not satisfied, you send it to HR is in the copy when you issue the query. And then the next line of action, you can then say, you know what, HR, please take this over for further investigation or something. So, which is the next line of next bullet point here. If it's a case of, is it fraud or something, suspicions of fraud, you know, what you can then do is maybe the audit team, the investigation unit, fraud and investigation, they go a step further in checking that. Again, I mentioned it before sanction is applied, please let's ensure that we have queried and the explanation obtained in writing. I mentioned it's not question and answer session. What is your name? And I've experienced it before where somebody just called me and said, please come to the investigation team. You are wanted. And then you go there. Your name, what's your name? What department? When did you join the organization? You write all of that. Okay, what do you know about this? I've gone to EFCC once, the one on Awolowo Ikoyi, and they sent a letter to our organization inviting me. It's not me, you know, transactions done in my capacity as an employee of the organization, not in my own individual capacity. And the reason was not stated there. But because I know my right and God is on my side, so it's not just about my right alone. When I got there, and they did everything they could do this, and I told them I cannot give any response because you needed to have given me a brief so that all of this information that you are asking me, I can prepare and get the documents, you see all of that. So we then had to reschedule for another day. So it's important, you know, when you're given query. Documentation of displeasure counseling sessions are sent to HR. I mentioned that appropriately. I mentioned that earlier, that these things are done, for record purposes. It's the responsibility of the supervisor of an employee to ensure that there is evidence of offense before referral for investigation. Where there is no evidence, it becomes clear that this is just a case of victimization. You don't like the person. Let's not mince words. That's just a summary of it. You want this guy out. We handled a case where they said somebody was collecting, I don't want to use the word bribe, but in the same organization, it was that before this guy carries out, he sits in a position where he needs to handle transactions for people, and that people need to settle him before he pays, before they can get their job, even senior people. That was where I got a bit worried. Why would a senior person, pay a junior person together? And the investigation was done and all of that. There's some element of culpability, but it wasn't clearly spelled out. So in cases like that, one just have to err on the side of caution. Applicable sanctions, like I mentioned earlier, they are applied after appropriate approval. There's a case that went to court about a particular financial institution who terminated the appointment of a senior person. There was a gap. Before people in that cadre are exited involuntarily, the board has to approve. Unfortunately, I think there was no board approval. The case lasted for a while in court. The decision of the court was huge. It was in the language of the comedian, it was huge. And all of the salary for about 6, 7, 8 years, the court mandated the organization to pay back, just because, yes, there's no doubt about what this guy what you said he did. DC hearing was done. However, that final approval, it was not done. When a decision is taken, employees shall be informed of the outcome of any decision taken. Informing this employee has to be done in writing, except where it's more of, a verbal caution, counseling, and all of that. There might not be some email saying this and all of that, but after that verbal counseling has happened, there has to be a follow-up to say, as a fallout, or as a result of this has been done, these are the steps and all of that. So, however, where you're having suspension, termination, dismissal, final warning, what other warning, there's final warning, and all of that. It must be clearly communicated to avoid any ambiguity there. And the evidence is also placed in the file of the employee, like I mentioned. And when you are sanctioning employee, their line managers should ordinarily be copied. They need to know, because you want to place an employee on suspension and the line manager is not copied. And the guy just comes to work and says, where is this guy? And he's holding very sensitive roles there. So HR must ensure that the line manager is carried along, except where, there's a need to be absolutely discreet in terms of some investigation that is going on. Okay, I think I mentioned organization bearing the costs earlier. So before I do suspending employee, I didn't put that here, but I think it's just important to mention it. Some of us work in organizations where we have what we call support staff, contract staff, depending on the name we want to use. Because of co-employment issues, what a number of professionals, or what would I say now, the advice generally is see. And what we recommend is, if you are trying to avoid that co-employment thing, if a contract staff or a support staff violates something, notify their employer, let the query be issued by the employer. It saves us a lot of storytelling and defending and all of that. So I just thought to mention that. I'm not saying is the standard practice is what everybody has to adopt, but it might just be a way of saving ourselves some stories that touch really. Okay, so when you've investigated the outcome of a DC hearing is that the employee should be on suspension. How do you manage that? Or you are investigating and you need an employee to be on suspension. So suspension can either be while the investigation is on or after the conclusion of the investigation. So where an employee is suspected of serious misconduct or where fraud or attempted fraud is alleged, the employee shall be suspended from duty to allow for proper, unbiased investigation. So let's not miss the reason, because for some people, the moment you suspend an employee, it means the employee is guilty as charged. So let's be careful. The reason we're suspending is so that investigation will not be impeded. It's possible. So that I said, the conditions, some of the conditions is not restricted to this, where thorough investigation is required when a matter carries the sanction of termination of appointment or dismissal. If an employee has been accused of what can I say now? Cash. Let me use a word in a phrase we use in the banking sector: cash defalcation, which is basically stealing money. If he's suspected of that, and you need to investigate. Now, if the outcome of that investigation is that this person is guilty, it's either going to be dismissal or termination. So where this is the case, so you are investigating an employee for pilfering cash. Will you allow that employee to still sit on your cash, knowing fully well that this person knows that you are investigating him or her? So in instances like that, there might be need for suspension. Now, it has to be timed. So it means that your investigation process has to, be as quick as possible, be thorough and be quick as possible. Now, if investigation of fact or the matter may be affected by the staff's presence, by the presence of the employee, if the employee's presence would impede or affect the investigation, there might be a need to ask that employee to step aside. So there are other instances. I don't want to restrict it to these two, but suspension is not just because again, there are several suspensions that the court has termed constructive dismissal. So we've got to be careful with that. We don't just leave people in suspending them indefinitely. And then at the end of the investigation on this matter, if the employee is not found culpable, recall and pay the entitlement. So usually you have suspension without pay. Labor law frowns against it. You have suspension with maybe half pay or something. So if anything had been withheld, then all those entitlements shall be paid back. And if found culpable, applicable sanctions shall apply. If they say the person stole money and it was established that the person stole money, and don't be surprised, people have come out to say, see, I did it. So whatever sanction that would apply, it would apply in those instances. Indefinite suspension should be only applicable in situations where careful or sensitive investigation is required and the end cannot be predicted. It allows for completion of disciplinary process in order to establish facts. So one of the two most common instances where you have indefinite suspension is where investigation is carried out by law enforcement agents or when the matter is pending in court. So here, employers have to play very, very, very carefully. We have to tread carefully. So a matter is in court, for instance, and then an employer goes ahead and dismiss the employee for, say, maybe theft. The dismissed employee will probably not say anything. Then years later, you know how our judicial system can be so fast. So the case is decided after 5, 6, 10 years. And then the guy is discharged and acquitted. He will come back to you. You see that thing that you dismissed me for? The court has said I am not guilty. And believe me, 90%, I don't want to exaggerate it, but more than 90%, the court will hear that case. And in most cases, the employer will lose because you dismissed him for what the court said he is not guilty. How do you then strike that balance? So let's play a scenario here. A guy has taken customers' money and he's charged to court. We don't know how long that matter will be in court. Are you going to keep that guy on suspension indefinitely if the matter lasts for 5 years? That's another case for court. So what should you do? Now, look at the details of the matter. In this case, the employee has taken customers' money. So let's look at it. What is the process? I'm using a bank, for instance, that I'm very conversant with, bank. What's your process for receiving customers' fund? So rather than focusing on something that will be decided by the court, employer, you cannot terminate or dismiss anyone and say the person committed a crime. You can't use that word. We do it, but it is illegal because it is the court that can decide whether this guy is a criminal or not. So what do we do in this instance? Let's look at the process and the procedure. Is there a violation of process? So for instance, this person is supposed to, if a customer is bringing in cash, this is the way it must be received. This is the way it must be registered. This is the time frame that this thing must have reflected. If any of those things are not there, then you have a basis for determining, but not based on theft, because that one is in court. In fact, if it is not in court, you have to be careful. You have to be careful. So in that case, maybe theft is dismissal, and then violation of policies and procedures is termination. Terminate the guy and move on. Terminate the appointment, not the guy, sorry, and move on. Because if you act based on what is in court, then you are just opening up yourself for potential litigation. So this is also an area where we have to be careful. Our time fast spent, but I think so. The other bits that I'll just quickly touch on, and as I've spoken about the termination of appointment, dismissal. Let's be careful. Your sanction grid is a good guide in terms of what sanction, so that you are not just giving out sanction arbitrarily. So my former organization, there's a document you fill when you're submitting, when you're joining newly. And we have a statement there that you must tick. That if we find out that if you give any false information, is a ground for dismissal. So if your age is 30 and you come and tell us your age is 27, and we do our background check and we find out, we will do all the investigation, like I said, and then is a ground for dismissal. But we will still query you. you will respond to the query and decision will be taken. We've had several instances like that. If it's a fraud case, what is the sanction for fraud? If it is if it's a violation of policies, to what extent do you then look at this is a first-time offender, this is a final warning, this is termination, and all of that? There are some infractions, for instance, that regulators frown about. Those infractions, they are weighty. You don't treat them because they are infractions that you possibly can lose your license for it. So if those infractions are not given the necessary weight, for instance, as an employee of a bank, I can't be trading in dollars and say, oh, you know, somebody has come to buy PTA, I'm trying to do all those transactions. Those people do it, but if they are caught, is enough ground for termination of appointment. So with this few points of mine, I hope I've been able to just share my thoughts and ideas on the disciplinary process. Thank you, Mr.
Thank you so much, Jimmy Mokikan. You promised me that this will be sharp and quick, and I understand. You know, I celebrate and salute you just for the, you know, offline, even though it's on record. Jimmy is under the weather. I didn't mention it at the beginning of the session so that you will not pity him, but now I need you to pity him. However, Jimmy, I told you we still stretch a little because the nature of this particular topic, there must be questions. If there are no questions, something is unusual, whether we either have the wrong audience or something. But true to our expectations, our a priori expectations, a few questions have come in. Let me start from the very first question. Even though I know the person that asks this question knows the answer, but not because of him, because of other people on this call. Jimmy, the first question I noted there, we'll first of all take all the questions that were typed before we take verbal, please. Kindly bear with us. While we prioritize typed over verbal, typed is concise, but we'll still call you, just bear with us. So the person says, Jimmy, what exactly do you mean by due process? You have been saying due process, due process, due process. What exactly is due process? That's the first question, Jimmy.
Okay, thanks for that. So, you know, when I was trying to set up and Yemi was talking about DC and a few things. So, do you have a standard disciplinary process? So, there is a general idea of what it should look like, but there could be some variances in terms of some little details. So, standard in the sense that if it goes to any court of law, will it pass the test of equity, of fairness? So let's look at the situation where somebody has been accused of, and I use the word accused because that's what some of us do. You accuse the person of negligence. Negligence. The conversation is, and then following that accusation, you issue a warning that you are hereby warned to desist from any act of negligence, and any reoccurrence will carry stiffer sanction. You know our terminology. Should you not know the implication of this, please get in touch with your HRBP for guide. Now the guy sits down and says, nobody has queried me. Nobody has queried me. So the due process for the disciplinary process is that if there is an allegation, before querying, get one or two facts together, issue a query, let there be an appropriate response, and let there be a response within an ideal time frame. This is to me, I say 24 hours, some will say 48 hours to give you time to get all your facts and evidence together. So after that, you can then look at, so you must have a policy. You must have a policy that guides whatever you do. Financial transactions, there are policies there are processes. So it must be seen that you have followed all of this process. Now, it's a different thing to fault your process. And if you hear some of the judgments of the courts, you will hear that the court nullifies maybe the termination of an appointment because due process was not followed, not because the person was not guilty of that offense. In fact, when they are guilty, what they typically will do is that they don't look at the offense, they look at the process. And I gave an example where somebody at a level, so maybe you are looking at, if you are going to terminate the appointment of a GM of an organization, it is only logical that it's not just the MD that will sign, because it's possible the MD does not like him. So maybe there will be a need for the board to sign. In that example that I gave, the board ought to sign, but the board did not sign. So in doing all of this, you must understand what your processes are. We set up an SDC hearing in my former office, and we found out that one of the guys had not been queried. We had invited him. It was an oversight on the part of HR. We had invited him, and when we start our session, virtual like this, say, oh, are you aware of why you are here? And the guy says no. So were you not given a query? He said no, that he was not given a query. At that point, there was nothing the committee can do. We had to go back, go and issue, let proper query be issued. Another point is that, so we said for the committee to be able to sit, a quorum must be formed. Maybe a quorum is 60%. If you have 10 people, 60% is that you must have 6 people in attendance. And those 6 people must include the chairman and the secretary of the committee. If those 2 people are not there, whatever decision you take is null and void. Anybody can challenge it. So these are things we look at to say, just ensure that you follow due process. And due process will vary from organization to organization. Thank you, Yemi.
Okay, thank you so much, Jimmy. Let me just add 2 things to it. So we're also trying to manage our time. So Jimmy, when you see my video, that means I'm trying to tell you that you need to wrap up on this particular point. But I need to add very quickly, just to reinforce what you are saying. 1, Jimmy is saying that for you to say something is due process, it must be a documented process. There must be something that can be referenced. Please note that. I'm trying to recap what he has said in a way some of you will better or slightly appreciate. It must be documented. You can't call something due process that is not documented, that is only in the head of HR or in the head of some people. It should be documented and probably signed. And also what? Available to the employees, to the union, to the organization. That's one. 2, one thing he has said, he used the word processes. That is why your standard operating process for various departments, various units is critical. Let me give you an example. Even our job description, it can be a basis. Somebody can claim that this offense you claim I committed, I didn't commit it. Why? It's not in my JD.
It's not in my JD.
Yes, that's why even your JD. So if you gave somebody JD 3 years ago, but you have done job enrichment or the job has evolved, you have not updated your JD, please go back and do it. Because the JD can be a tool in court to nullify or to be to stand against you that you are not following due process. Your employee handbook too is very critical. So if you are in a unionized environment, for example, your condition of service will also detail things that will show or reflect due process. Now, the next question, Jimmy, you have just 2 minutes to answer this one. Why? You have answered it during the course of this presentation, but in case of 1 or 2 people who came late, the question is straight and direct. And the person says, is it right for a line manager to instruct HR to issue a query? Over to you, Jimmy. Is it right for a line manager to instruct HR to issue a query?
You have, Yemi, that 2 minutes that you give me is too much. Why is the line manager asking the HR to issue? The line manager should go ahead and issue the query. Don't just dump everything on HR. And then at the end of the day, they make us feel bad. They make us look bad. So the line manager should go ahead. That's what we will take it up from there. Thanks.
Okay, Jimmy, thank you so much for doing that in a GB. Now, this is not a question, but I found it instructive and important. So one of my friends, very good friend, mentioned in the chat group that, okay, MD typically says policies are not cast in stone. Jimmy, you don't need to answer this, but you can say something around it. Let me respond to it. You see, while I agree with your MD that policies are not cast in stone, as long as you have not amended the policy, it's cast in stone. When you get to court, you will tell my Lord Justice that it is not cast in stone. Once it is written and signed. So now, where that allegory that is not cast in stone comes in is that if you think the policy is no longer working, you can amend it. Then I will agree it's not cast in stone. Amend it, but don't leave it unamended and say it's not cast in stone. Please, so your MD not at Kirikiri. All right. Do you have anything to say to that particular question, Jimmy?
No. Let's move on.
Okay. Now, there's another question here, and the person said that, what if, for example, you issue an employee a query or invite the person to face the disciplinary committee, and then the person sends you a resignation with immediate effect? How would you handle that? Or how should HR handle that?
Okay, so number one, there is a battle I usually have with some of my HR colleagues when they say they want to accept resignation. And I tell them that phrase, accept resignation. Somebody has resigned, he has resigned. There is nothing like accept or not accepting. However, if the person has resigned in the course of investigation, is there an evidence to show that query was issued? If it was sent to the person's email, he or she cannot deny seeing that email. So note it in the records. It could be for reference purposes. It could be useful. And if you think he resigned because there are tones of criminality involved, hand over the matter to the people who are empowered by the act, which is the Nigerian Police Force, to handle the matter. In the financial sector where I come from, instances like that, we write to CBN and we tell CBN, yes, this person did not face the DC, however, resigned in the midst of investigating this action. So if it's something you want to push, please hand it over to the police if it involves criminality. If you have regulators that you give accounts to, make it known there, but you cannot emphatically accuse that person and say this person has committed this crime.
Thank you so much. Again, I appreciate sincerely all the feedback that I've been dropping. And this is why, even though we have a lead facilitator, based on the wealth of experience and wisdom in this house, we encourage us to share our thoughts. Coach Olubusola rightfully said that in the public sector, line managers send in report of misdemeanor with respect to an employee, and HR will issue queries as needed. So you need to also realize that there are certain peculiarities between private and public. Even in the private, there are also certain peculiarities within certain industries. So, for example, just mention financial sector where you can write CBN. Some other sectors may not have that level of regulation. Are we together? So what we are doing here is to provide you a broad framework. And if you have information, please, like Coach Olubusola has rightfully done, please share it so that all of us can get very robust takeaways. Thank you so much, Coach. I salute you. Jimmy, I don't know if you are checking the chat box so that we can see some questions. But while we are looking at the chat box for questions, a certain Charles raised up his hand initially. Charles, if you are not upset with me, please raise up your hand again. I will call Abimbola, but Abimbola is my personal person. Abimbola, don't say a story, ask a question, okay? If we do it in 30 seconds, I owe you a bottle of Kunu when next we meet. Abimbola, unmute and quickly ask your question. 30 seconds for the Kunu to be activated.
Good evening, sir. Okay,
Good evening.
so good evening, sir. Thank you very much for the everything. So my question goes to we that we are working in SMEs, that all of these panels that are not existing. It's just you. I'm the only HR, and the boss is the person who has a say. He will just see somebody that is putting leg on the table and say, send this person on suspension. And there's nothing you can do. And as you're talking, I don't know, how do I come in here? That's just my question. Thank you.
I don't envy you, Abimbola. I don't envy you, sincerely speaking. And I've had a taste of it, although not an SME, where, like I mentioned earlier, somebody just says, give this person query for not coming to work. And my response was more like I was challenging authority. But we'll just keep, it's a tough call for SMEs and I saw another chart, someone say about one-man business. However, sometimes maybe HR, what we need to also do is to try and let them see us bringing values. Maybe at the heat of that moment, it might be tough to have an engagement. But you see, if I made a justification for somebody in my office for a promotion, and the response in the heat was, no, this. And at another point, I found the time to just sit and say, this is what I'm asking for. If this person leaves, we are going to pay more. We are going to spend time searching. We'll probably pay agency or something. And then, people begin to see. So there are times when we need to just find a way. And I pray that God will grant us wisdom to do it. But it's a tough call but what we can also then do is to say, see, Oga, see you, just in the spirit of fairness and all of that, just have one or two people, put them in the committee, let them just review, to give a benefit of a doubt and all of that in it. But sincerely, it's a tough call. I don't envy anybody in that situation.
Okay, so let me quickly take one or two questions here. Again, without disrespect to our facilitator and with his consent, I will be responding to some questions also because of time. Loretta Odoro says, can an employee be suspended without pay for gross misconduct? Jimmy mentioned that there are certain situations you can suspend, typically in the context of an investigation. And he advised that the suspension should not be indefinite. It should be finite and reasonable. So not that you suspend somebody for 6 months or 3 months in perpetuity. Okay, maybe 2 weeks, 1 month, wrap it up and close it out. Okay, because some people want to use that suspension as a means to punish people. If the person goes to court, you will pay for the period of suspension. Because when you suspend that person, the person will not go and seek employment elsewhere. The court will not want any employee to be hungry. So please, let us note that. And when you are suspending without pay, it should be written in black and white that the suspension is without pay. And the reason for the suspension. Don't just assume. Because some people suspend people for like 2 or 3 months. After, they will not terminate. You will still pay. I pray that more employees become more litigant in nature. Even though it will take time, they will get them victory. Roslyn Ausa said, can suspension be used as a form of disciplinary punishment? I'll also answer that question. Yes. However, I'm saying the yes in a context. Ab initio, you should have a disciplinary or consequence grid. There should be the different types of sanctions. For example, maybe verbal caution, first written warning, second written warning, final warning, suspension, termination, dismissal. If you have clearly articulated the different types of, so to speak, punishment, and is approved by relevant stakeholders, not that you will not be handling a case. Now, this case is special. You will not invent a special type of punishment because of that case. Then it will appear premeditated. That's why your disciplinary policy and process or administrative process should have been done ab initio, upfront. Don't do it during a case. Please note that. And Jimmy, just help support me by checking through.
Yes, so I have a question here, Yemi.
Okay, go ahead.
It says, my question is around service no longer required as a reason for termination. Is it right to use that clause and still fill the role upon termination, especially when there is no other reason given in the letter, service no longer required? The court has said you cannot terminate for service no longer required. So that's the very simple. You can't terminate for service no longer required. Otherwise, you just be opening up yourself. And you raised a very valid point. So you terminate the person for service no longer required, then you bring in another person for that same role and all of that. However, when that judgment, there were some land bank judgments. I don't know the cases now. So when that happened, employers started using in line with your contract of service. In line with your contract of service. That is also being debated, but that's what a number of organizations use. However, if you are terminating appointments for an infraction that has been committed, because of some of the things that we have also seen, you must state the reason. That's what the court says. However, in stating the reason, be sure that you have every fact and evidence to back up. If I say your appointment is hereby terminated for your negligence in processing a customer's transaction, I must be specific that if it goes to court, I will be able to defend it. But if services no longer required, the court has said no.
Yeah. What services no longer required sometimes feels like is like, Jimmy, I don't like your face.
Yeah.
Please take a walk. It's very flimsy. Now, let's quickly take a few voice questions. I see my sister here, Mary Adeyemi, long time no see. Mary, please, I've attempted to allow you to ask your question. While I'm at that, Yemi, Oga Yemi.
Good evening, sir. Good evening, sir.
Go
Thank
ahead.
you.
Yemi, please be patient.
Okay.
Let Mary go first. We must
Okay,
not be
sir.
abusers.
Thank you, sir. So my question is, in cases where you have external people, which are your customers that have come with allegations, does the employee need to get a query first, or you can go ahead with your investigation and invite the person to the disciplinary panel?
There's a bit of disruption, but I think I got the question where there's a complaint from a customer. So the typical thing is there has to be an investigation. Again, my experience in the bank, you have instances where a customer complains to say, I paid money to this person, but it's not reflecting in my account. You have cases of you even find it out on social media where some aggrieved customers will go on social media and mention names and all of that. So you will investigate. Recently, I think it was it last year or this year when all of the toxic, the thread on toxic environment.
Yes.
My former office, there were names that were mentioned. We did our investigation and we gave queries to some people after that. We didn't take any serious action because some of those things we really couldn't substantiate them. So if any complaint is coming from a customer, yes, investigate the complaint, investigate the involvement of the employee. And if there are chances of negligence or anything, appropriate disciplinary process should follow. We had a case where a customer reported directly to the MD of my former office, reported directly to the MD how her transaction was delayed. And she did screenshot her time in the bank and everything. And then we investigated and the person faced the DC because really you are there to serve the customer.
Thank you so much for that apt response. Let's quickly take Charles now. Or Yemi.
Yemi,
Yeah, Yemi, go ahead. Charles, please be patient. Just hold on, Charles. Yemi, go ahead.
All right, thank you. Good evening, everyone. This is Yemi Fashion. I just want to quickly go back to a point that was raised about policies, right? Yes, the succinct response was that policies are cast in stone and concrete and steel. However, can I say that there is always room for discretionary approval. And it is because we have instances that might be outside of the policies at the time they were written that we must make room, therefore, for discretionary approval. I'll give you 2 instances. Number one, at one point, we had a leave policy or around health, and it was 3 months full pay, the next 3 months half pay. After that, possible termination. But there was a lady who had a cancer issue and needed the money to do the treatment because it was outside of the scope of the HMO. I got an approval for her to get paid for the full 1 year while she was going through treatment. And I got EXCO approval for it. That was outside of the policy. Now that's discretionary approval. In another instance, you have a reward policy that says people must be brought in at certain salary ranges at different levels or grades. But for whatever reason, you got a talent that you want to bring on board, and this person is already earning over and above the grade you want to bring them on. You can seek exceptional approval, despite the fact that we have a reward policy. What needs to happen is that discretionary approval shouldn't become the norm. When it's becoming the norm, it means that the policy itself is becoming outdated. So it needs to be quickly reviewed. But let's not stay in the place of saying that once policies are written, or then it is cast in whatever it is, there is always room for discretionary approval. I just wanted to point that out. Thank you.
Yeah, very apt, Yemi. And let me just allude to what you are saying, so that we are using this casting stone, YF, in the context of DC. What do we mean? An infraction has occurred. You now want to charge an employee for an offense. You cannot be changing the policy or the purpose of that case. Otherwise, it can appear vindictive. You can try that case as it is based on existing policy requirements. Immediately you have dispatched with that case, you can now update. Do you understand where this particular context is? Your points are very valid and very noted. So we're not speaking to policy in its entirety. We are saying where it is affecting an employee that is in a disciplinary dispute. Already there's a dispute, a disciplinary issue is on ground. Because if you go to court, they will look at the dates, there will be stamps. When was this document signed? When was this? So, and you may not be able to apply a new policy in retrospect. But if we are talking about policy in the context of, for example, maybe employee welfare, advancing the organization, there's no DC case, please, by all means, it is not cast in stone, no, please, all right? But very brilliant point, YF.
Thank you. I mean, I just did an approval for somebody's wanted to bring in someone, and the pay is outside the range. I just did an approval. Thank you, YF. Thank you. Good to see our senior men.
Charles, you have the floor, please, Charles. Charles was the very first person to raise his hands today. I don't want him to take me to DC.
All right, sir, thanks for the opportunity. I'll quickly go straight to the question. Thank you, Mr. Jimmy, and thank Mr. Oluyemi Adeosun. Okay, speaking to an issue of query now, and then for some of us that are in third-party employment, like working outsourcing space. So we have instances whereby I have 2 scenarios, whereby you send them, let me give the instances, whereby you send payrolls to your clients, and while coming back with approved payroll, you notice they have deducted from employee salary. So when you read that, they come back and tell you it's due to poor performance. Meanwhile, you ask for query. Have you engaged the employee before now? Is there any query? Is there anything you can track to this? Have you advised them through PIP? So they come back and say, oh, I've warned him severally. We have verbal discussion. So in that instances, what can you do as a secondary employer? Because this can actually lead to litigation in the future. And secondly, I have another instances whereby the bank dealt back end, they give some of our staffs, our secondary staff, they give a staff a query, or even take the staff to a police station. They detain the staff. In the process, the family bailed the staff, and from there the staff resigned without coming back to the secondary employer. Now it's a big issue. The staff has actually charged the bank to court, and the bank is now coming back to the secondary employer. In that instance, what do you think we can do, sir? I don't know if you get my question.
Yeah, I got it, although my network was kind of fluctuating. So, you know, I mentioned briefly, because it's a deep dive when you go into the co-employment thing. And personally, I just advise, as much as it is possible, let's let those boundaries, as much as is, you know, we can do it, to clearly set it. So oftentimes, especially for financial services, I don't know why we refuse to learn. Because see, if you are dealing with CBN, for instance, CBN is not going to look at the third party, the employers of these guys. They are going to look at you. So we get so very involved in their activities. I'm not going to allow anybody do unnecessary deduction. It's illegal. If you haven't given me a query, and you haven't, it's why are you deducting my pay? Is it, again, like I said, where some of these structures are not in place, is a tough place to be. But it's sometimes, that's why you see some HR people, it gets to a point, and I have a couple of friends who, they just can't take it anymore. They leave. When they try and they just realize these things are not happening. But it's illegal. You can't just be deducting people's salary without any query, without anything. Even if I have come late, show me, at least query me. Let's get to know that, oh, I came late. And the punishment for lateness, really, is it to deduct my salary? So, Charles, I don't know what exactly you would do, but I think HR will just continue to make it as open as possible. We shouldn't do it. We shouldn't do it. The fact that we're doing it, we're going away with it. And then maybe that organization, okay, you did mention that maybe they are going to court or something. If organizations lose cases, we will learn from it. We will learn from it. We had, my former organization, we had so many cases in court, so many. And some of these cases, they have absolutely no reason to be in court. So one of the mandates is, see, the ones that we see that, oh boy, we have goofed, let's just see how we can do out of court settlement. We started doing all of that to reduce those things, because there are some of those things that there is no need for them to be in court at all. There are no need for those cases to be in court. So it's a tough place to be. Whatever changes that God can help you to make, you will continue to make it. And then maybe some of these things also, let it be documented. Because the other thing I observed, that a lot of mistakes I also make it, is that we just say it. There's really nothing documented. And you know, when YF was speaking, I did a mail yesterday to my CEO, in fact, almost midnight this morning. And because the organization is, some people are insisting that we bring in someone. Now, this person, when I look at the pay and all of the fitting, is a talent, but it's going to cause too many distortion. So I did like a long write-up. I didn't know where the anointing came from. I did all of the comparison and all of that. We've been on it for close to about 2-3 weeks, and it's been, bring this person in, why are you not doing this, why this? And I did that and sent it. And you know what happened is, just one line, he aligned. I then looked at myself, oh, maybe I should have written this long before now. So some of these things I will advise, Charles, let's document it. At the end of the day, the conversation will be, so what did HR do when all of these things were happening? But you have the document, you have the records to show that, okay, these were the steps, these were the efforts that were made then. But to say this is exactly what you should do, maybe Toles will bail me out.
No, Wala. Someone has rightly mentioned in the group that this particular topic looks like there will be a session 2. It's sounding like a Korean movie series. But let's quickly take Mabel. Please, I will appreciate sharp and concise. Mabel, you have the floor. After we take Mr. Morakinyo, comment, question, or feedback, or all combined.
Thank you. Good evening. I hope I'm audible enough.
Yes, Mabel, loud and clear.
Okay. I listened to your explanation on the stating the reason for termination. So a management staff was recently terminated, but the lawyer advised against indicating the reason on the letter. So the manager did not pass through all the requests that we gave to him while we were resuming back to work 100%. And like Mr. Mokikan said earlier, we have this caution in our letter of engagement where we have said that the company has the right to terminate the appointment of any staff given 1 month in lieu of notice or salary. My question, do you think we have erred on the part of caution?
Okay, just to clarify, so the letter, what was the content of the letter?
So we had given a deadline for resumption because he said he was ill. And then we requested for a doctor's report. He did not submit. We have written severally insisting, and this went on for 4 weeks. So we quoted that part of the handbook for him to say that the policy, the company's policy say that they can terminate your appointment at any time. However, we then gave a deadline to say, if you do not resume on the 1st of August, your position will be declared vacant. So that was the last one. And when he didn't show up, we went ahead to get an approval from the chairman of the board to terminate. So I specifically said we shouldn't use the word terminate, we should just say disengagement.
Well, it depends on the judge that is looking at that, decides to look at it. But you simply have just terminated for abandonment or abscondment.
Yes, that's job
if you have a
abandonment.
policy,
Without
if you have a
providing
policy,
legal advice.
yeah.
Did you attempt to visit the person at the hospital, for example?
No. He's been here. His family is in the UK, so he traveled to UK. And when we rolled out the email to say we are resuming, he said he wasn't coming. I specifically called him. He didn't even send an email. So I advised him too as a management staff.
Maybe just to, because of our time, right? We dealt with several cases like that in my office. There were people who went to UK. There were some that, in fact, one of them, we asked him to come. He told us he was back. He told us he was back. It was when I said, oh yeah, go and resume in the office. Let's see you. That was where everything, and what we did is resume. If you don't resume, like Yemi said, all of the necessary back-end support that HR should give, let's check. We requested for medical report. He brought in a fake medical report, but we won't be going into all of how did we know it's fake and all of that. But we have a policy around abandonment. And so we just activated the termination based on abandonment and all that. So if you have used disengagement, if you have used termination, the guy can still come up one day and says he was unjustly terminated. And if you want to now say tomorrow that, you know, you terminated his appointment because he wasn't at work, he abandoned, your letter is not stating it. My former employer has a case in court that we're trying to settle out of court because the guy faced panel, but the letter was silent about what he faced. And then we now reported him to the regulator. So I think it's something
what you just said now, if it's not you, I would say it's a joke. But I know it's the truth. You know, the kind of flips that happen in HR or in organizations can be happening, but don't be caught. That's why we're having this session. Let's quickly take Mr. Moraki up quickly. Then we'll come to Olasumbo.
All right.
Thank you, sir.
Good afternoon, and thank you, Mr. Mokikan, for your presentation. How are you?
Very well, thank you, sir.
All right, let me quickly make allude to the last discussion. You know, there's also something we call unauthorized absence.
Yeah.
And there's a rule under that. So what he was talking about, if somebody is not at work, what does they, I mean, you are talking about abandonment. Unauthorized absence to, normal, maybe even if you're sick after 2 days or 3 days, what do you do? All those processes are in your handbook. So if you have flouted it in writing, those are things we will refer to build case. So even if you are going to terminate and go to AFA, you will have been able to say that there has been breach of those processes or rules that you didn't follow, rather than just saying you're terminating, just like you have said, without mentioning the reason, and that could become litigational. And then NIC is very, very strict about all that. So if there's something like unauthorized absence, in addition to the abandonment or whatever, those are things that HR officer should clearly state. But if the guy knows all those who are there, it's either to quickly turn in his resignation letter, which will address the issue, rather than waiting until it becomes a ding-dong affair. That is one. The other one I want to talk about was the one mentioned on the SME. It is a problem too many, because they are always in a hurry to take decisions to disengage, because this Nigeria ego thing, I can fire, I can hire, that kind of a thing. And you now see attrition rate of HR practitioners. You get to a particular organization, I handle a lot of them recently when I try to consult for them. In 2 years, 7 HR managers or more. Are you getting me? Because just like you said, some of your friends, we have to take a walk. So we also have the responsibility as HR personnel. But the challenge we have that people rush to work because of the need to get something done without doing some research. And when you also get in, when you are engaging, you try to engage the need you are needed like yesterday. It's an opportunity to be able to ask some question. Do you have this in place? If you don't have it in place, are we going to put all this or that? To some extent, you are indirectly educating them of the need for them to ensure processes are followed. Not all of them will listen, but some will listen. Those who will listen, they will be converts to us to make the job of HR practitioners very easy. I hope you are with me. So that we don't come here and be talking about the same recurring issue. How do we bring in business owners in SME space to understand that they need to follow process before taking decision? You are the owner of your, nobody is doubting that. But you should also know that it becomes a problem for HR person. You go to a problem when you just call on phone and say terminate or sack or whatever without having to do query. That is the second observation I want to make. Then finally, I think this type of session should be on the continuous because of our young people coming in. Because all the questions that have been asked before today, I've told you a lot that quite a number of people are going through a lot of issues over issues that you have taken your time to explain. So, and like Yemi said, having a second session will not be a bad idea, so that we can have more time to assuage some of their fears, and we can also be sure that this group has really helped to ensure that our people run out of the murky waters of problems of HR. Thank you very much.
Thank you,
Thank
sir.
you so much, Dr. Oloyede, for those
welcome.
relevant contributions. Okay, again, let me just quickly put it out there. No matter what, we're in this session by 9 p.m. No matter what. Otherwise, some of us will face family DC. You can understand where we are coming from. Olasumbo, you have the floor, please, for your contributions or questions.
Thank you so much. Good evening, our host and the entire HR community present here. I have a question, and it's centered around, well, let me first of all say thank you for this insightful session. My question is centered actually around performance memos and warnings that we issue from HR, especially in the financial institutions, where you have marketers coming in at engagement and promising to do certain obligations around targets. They must have promised you heaven and earth to say, oh, we can do this and this and this. And at the end of the day, after 30, 60, 90 days, they have not even done up to 10% of what was agreed to. And in most cases, HR will go ahead to issue warnings. And of course, if they have not performed up to expectation, the next thing is to start looking around, how to cut down salaries, or, how to ensure that they perform. So I want to ask, what are the best practices around issuing these performance memos and warnings? Because in my organization, what we do actually, and we have a clause like that in the offer letter to say that after 90 days, you might not be paid what was agreed with you at engagement. So what are the best practices around issuing these memos and warnings to marketers, especially in the financial sector? Thank you.
Thank you, Olasumbo. Thank you for that. So I've been privileged to work with some very fantastic HR top executive. Yemi, if I'm permitted to mention name, I'll mention his name if I am. And in my former office, head of HR. When people are coming in, people come in with this. In fact, all of the cattle on 1,000 hills, I will bring them. People give promises, and then we now set expectations based on those promises. But ab initio, it was a promise that was deemed to fail. Because you know that all of these things, they're not real. So at some point, our former head of HR had to ensure that that process stops. If you give somebody if somebody is even telling you he's going to do this, and we know it's unrealistic. So I think the first thing is, let's put an end to that thing. It's not realistic. So you know that this person cannot achieve it because this person wants to take it. And I don't know how it happens, how it works in other sectors. But in the financial industry where I've worked for over a decade, right? Because people want to get promotion, people want to get next level, they would tell you anything to be able to get the job. But it's becoming clear that those things, they would work negatively in the long run. So first and foremost, we have to put an end to it. Secondly is, yes, let's review performances. However, let's be fair. Let's be fair in terms of the expectation. If at the end of whatever the probation period, the person did not meet the agreed threshold, the realistic agreed threshold, there's we do it, we let people go. However, some would give me an option to resign. Some would resign. Some will ask for option to resign and then go to court and said, yes, I resigned, but it was you that motivated. It was a premeditated action at your end. So we just have to find a way around it, right? But from that expectation point of view, let's manage it. If somebody is coming in to say, I'm going to bring all of the federal government accounts, and you know that, how will this person do it? I think HR needs to step in. We've left so many things as HR. We've left it for functional managers to manage. However, it's time for us to take up those initiatives and this, so that we can see the value that HR is adding to the business. I hope I've been able to maybe provide some response. Anytime I see changes,
I'll just add two things to that, Jimmy, because of time. Just because of time. So Jimmy is saying that, one, is it reasonable? Is our performance expectations and performance requirements, will it pass the reasonable man's test? That's one. Two, is it sustainable? HR must increasingly embrace sustainability in our decision making. But because some things have been entrenched in the industry, it will take time. Okay, then also, how are we measuring performance? Are we measuring performance strictly based on the finances or funds that person is bringing in? Or are you looking at the pipeline? Because sometimes some sales activities require long gestation period. Except that person is a miracle worker. Maybe you are the governor is your cousin. Once you change banks, it even takes some few weeks to move the state accounts. Let's note that. We'll quickly take Sheyi. Sheyi, please. I'm begging you, because of the 9 p.m. barrier, not to do more than 2 minutes. Then we take Rita Babalola, which will be the final question. Please don't raise up your hand again. I won't see it. Sheyi, you have the floor.
Yes, thank you, Yemi. I just quickly want to say that it's a different ball game again in a unionized environment where you handle union. Also, the issue of victimization has been seen when you issue query or you want to follow through your policy to deal with these hearing members. So one needs to be careful, and I'm sure we're going to get to that section. Also, for the financial sector, it will be good to familiarize ourselves with different NIC judgments over time. This will help us in future dispensation of disciplinary actions. Thank you.
Thank you so much, Shay. Thank you so much. For those of you on the mentorship group, if you have seen our lineup of programs, we'll have a session dedicated to union management. I will take a cross section of different HR practices and how it interfaces with the union. Our final contributor or questionnaire for the day, Rita Babalola. Madam.
Okay, so thank you, Mr. Yemi, for allowing me to come on. This is in direct response to what the other lady has about marketer, sales executive. Maybe because I've always been in marketing, and honestly, what we have in the HR space or what we have in most organizations regarding evaluation of salespeople, business development is mostly unfair system. When you go into sales, if you get somebody new to come into any employment, a new place, we always forget this team formation, the elements of team formation. When people come into the organization, they need to get acclimatized into the system. They need to get integrated into the system. You can't employ me from day one in any financial institution and expect me from day one to go out there to go and start competing with bigger banks, where you have the likes of GTB, Zenith Bank, and you're telling a microfinance staff as a business development person to start looking for 20 million, 50 million. If I come to you ordinarily and I say, oh, I just got employment into ABC finance company, are you going to give me 1 million or 2 million to just put in an unknown microfinance bank that has not even advertised itself in the marketing space? So I think more as an HR personnel that we are, we need to be strategic in our evaluation and performance review for salespeople, number one. Then number two, when you go into sales, just like what you sell, there's always a gestation period. When I get into organization that I'm consulting and you tell me your sales, your marketer have not performed, I say you cannot evaluate people after 90 days in sales. Sales goes through a sales process. It goes through a process like you are rebatting, you are doing everything together. So an average salesperson may take more than 90 days. And if you put it in an offer letter and say, oh, if you don't bring this, then we need to call the HR personnel to question too. Because that means you are not abreast of what is happening in the context of your organization. So I think we need to look around and reshape and remodel our performance evaluation system for salespeople. You can't limit them to 30 days. You can't limit them to 90 days. I think a fair system will start from 180 days. Some still needs to get integrated into the system, get to even know the organization itself. Then they need to get to know product knowledge about it. And then you're pushing them to come and start making sales from day 90. It's not going to be easy for them. So let's be realistic about setting targets for salespeople. Thank you.
Thank you so much, Madam Rita. Thank you again. Let me use this opportunity to appreciate Madam Rita. We see what you are doing in Group 3, taking time, quality time to provide quality responses to those questions. We celebrate you. I owe you.
Thank you.
If we meet at any hangout, I will pay for your menu. It's on me. And if you come with bros, I will pay for the two of you. Thank you so much for what you do. All right. Jimmy, you have 1 minute to do closing remark. But just before you do that closing remark, tomorrow we'll be having with us Kenny Olubemi, who incidentally is also Jimmy's friend. She's also my friend. We'll be coming tomorrow and speaking around and about building an effective and efficient talent management initiative. On the mentorship group, we will share the login details of the Zoom. Just to let you know, we have capacity of only 100. Sign up on time, join early. You have witnessed today's session at least. And also, I'd like you to know, for today's session, some of us need to listen to it again and again. Please go to the YouTube link. You will see it only in my audio. I've also dropped the link. Please subscribe to the channel, help my ministry, okay? Help my career. Subscribe to the channel. You also previous editions of our mentorship program. Listen to any of them. For example, for everybody on this call, I did a session on labor law. Go and listen to it. That labor law is foundational to what we did today, because it will guide you on how to even come up with policy and what not to put in. Because your policy cannot be opposed to a labor law. It will be null and void. All right. I don't want to say too much. Thank you so much. Jimmy, I'm tempted to say, will you say the closing?
All right, thanks, Yemi. And I could feel the passion with which Madam Rita was speaking. Thank you so much. Thank you, everyone. Thanks, a pleasure. Maybe just the final word for me is I think as HR people, we need to show a lot more empathy things will be thrown at us, but just before you throw out that query, just before you do it, let's even get to maybe put ourselves in the shoes of these people. Let's get to know, if somebody whose performance has been excellent, suddenly performance start dropping, let's try and just dig deep. And I deliberately didn't go into anything union. I worked in an environment that is highly unionized, but looking at the time frame and all of that is a different topic, and I know a lot has been handled on that. Thank you, everyone. Thank you to all our senior colleagues for the opportunity, for the privilege. Thanks, Yemi. I really call you Yemi though.
Just one more favor, Jimmy. There are still a few questions on the chat box. So you can type the response, Jimmy. So we will end the meeting, or I will stop recording, but we won't talk, just go through the chat box. So if you have a question that has not been responded, stay on the call. All right? I will also look at the questions myself and respond, and any of the people on the call can respond. I don't want anybody's question to be left unattended to in the chat box. Officially out.
Thanks. So Yemi, okay, but I think there's a question around. Sorry, I'm looking at two screens. Okay. There's a question around board member. I saw it.
Yes. That's, I think, the husband of a board member or something. I sent a small response, and I mentioned something around corporate governance being involved even without particular situation.
Yeah, corporate governance is key, and I think conflict of interest and all of those things.
Yes.
Yeah, it should. But of course, we're talking of organizations that are standardized organization. Yes. Where it's not, it then becomes a challenge. I'm looking through.
Just glance through. Of course, the question cannot be new. It must be a question that had been on the chat. I don't want anybody to feel alienated. Okay. If you like to join the mentorship community, you can also fill the form. It's on the chat box. Thank you. Somebody, I saw Doctor asked a question about Mabel, that should Mabel now go back and try and, revise or review the termination. And I responded in the chat box that would not be necessary. The only thing I can suggest you do is you can call him offline, just have a conversation with him and cool him off. Most of the time, or some of the time, HR should do this. Don't just be administering letters. Also call people. Sometimes when you discuss with people at length, let them look at it from this side, look at this from this side. This is how we came about this decision. By the time you are giving them letter, they will have calmed down. Don't just be, like a robot. You just issue a letter. Don't be cold, please. I tell people there are some letters you shouldn't deliver via courier strictly, or you just call people via Zoom. If you want to give someone bad news, don't use Zoom. Call the person face to face. Jimmy said it, empathy. If 50% of cases that went to court, if HR had handled this slightly differently, the employee will be angry, I agree, but they will be assuaged. They will be angry, but you will be able to pacify them. Of course, I'm not talking about where you cheated people or you did something completely uncalled for. Just treat them like a human, engage with them, okay? Jimmy, any question you want to respond to? Okay.
Sorry, I didn't know I was muted. So right. Yeah, there's no new one. Either response from participants from the chat or during the interactive session.
Okay. So do you want to say something to Dr. Joyce's question on the board member? Although I know we've mentioned corporate governance and we've also mentioned what do you call it now? Conflict of interest. You may also need to do a report to the MD or to the board to bring their attention to it. Because don't forget, Jimmy didn't mention that word. Let me just wrap up in 2 minutes on this. Jimmy, let me just wrap up. You see, when you do something and it flies in the organization, there's something we call precedence. And court also use it. Once you have accepted it, or somebody did something you are supposed to punish, you didn't punish, any other person that does any other thing like that, that becomes the new standard. Because if you do anything contrary, it will be seen as what? Discrimination. So you must be able to articulate all these things. In conclusion, just 2 more points I want to draw. Okay. One, there's what we call procedural justice, the process by which things are done, which Jimmy had been hammering on. 2, there's what we call distributive justice. When Jimmy is saying, is it fair? For example, somebody comes late for 5 minutes and you deduct the salary for a whole day. Is it fair? Okay. Thank you so much. Jimmy, we need to be out of here. I'll see you maybe on Monday or Sunday. I'll end the meeting for all. Bye. Bye, everyone. Thank you.
Thank you.